I'm Christine Wilson, and it is my distinct pleasure today to interview Tim Muris for the Oral History Project of the ABA Antitrust section. Tim is currently of counsel at O'Melveny & Myers and Foundation Professor of Law at George Mason University. But today we're going to talk about the roles that Tim has played at the Federal Trade Commission over the last 4 decades, and during the course of those roles, the unique perspective that he has obtained from those experiences. Tim, it's a great pleasure to be with you here today.
Thank you.
So I think we should set the stage by talking about the different jobs that you've had at the FTC over the years.
Well, Christine, I'm a government recidivist. I've had about a dozen different kinds of jobs with the federal government, including 6 full-time ones. At the FTC, I started as a student intern in the LA regional office in early 1974. Then I went full-time with the Office of Policy Planning, where I was an assistant to the director. Then I came back in 1981 as director of the Bureau of Consumer Protection, shifted over about 18 months later to be director of the Bureau of Competition, and then I became chairman for 38 months starting in June of 2001.
And you're the only person ever to serve as head of both bureaus, is that right?
Yes, not at the same time, no.
So we know you have very strong views about the role that the FTC should play and the roles that the FTC should avoid when regulating commerce. Can you share that vision with us of your ideal FTC?
Yes, the FTC is an important agency, but it's the referee, it's not the star player. We have a market economy. The market economy serves us well, but a market economy needs rules of the road. And the basic rules are so simple we don't even think of them as rules. There's don't breach your contract, don't engage in deceptive advertising, no unreasonable restraints of trade, no fraud. And that's what the FTC, that's its most important mission, is to enforce those rules. Now, it turns out that there are private institutions to enforce those rules, like class actions, small claims, individual lawsuits. But for the average consumer, those don't work very well. So the FTC functions in the role of protecting the average consumer to enforce those simple rules. Unfortunately, in the history of the FTC, particularly in the 1970s, that wasn't the FTC's vision. On the consumer protection side, the FTC's vision was, we, the FTC, are the second most powerful legislature in Washington. That's just an inappropriate role for 5 unelected officials. On the competition side, the idea was we will enforce the simple market concentration doctrine, the idea that big is bad. Well, we've grown beyond that. And I think in the last 30 years, the FTC has had a solid, simple mission. But again, it's the referee, it's not the star player.
Thanks. So let's move now to the specific missions of the FTC, starting with consumer protection. So when you were chairman, you launched several initiatives to buttress the fraud prevention program of the agency. It would be great if you could share with us the growth of that program over the years and how it came to be the powerful force that it is today.
Well, if you look in the 1970s, the FTC really, when I was there and throughout that decade, the FTC really didn't go after fraud. And I think a lot of the reason was they felt there were ineffective remedies. When I came back in 1981, we decided as an experiment to use the 13B of the FTC Act. And that act, it turns out, successfully gives the Commission great powers. It can go into court ex parte without the fraudsters knowing, tie up assets, save the money for consumers, get good injunctive relief. That's turned into a tremendously successful program. Each new chairman has added to it, has improved it. When I was chairman, for example, one year we got nearly $800 million back for consumers. We extended the program to the Spanish language. The FTC hadn't done anything in Spanish language media. That's been very successful. Hired lots of attorneys who speak Spanish, work with the Spanish language networks. We also started a criminal liaison unit. A lot of these fraudsters really belong in jail. A lot of the fraud is basically crime. The FTC does not have criminal authority. So what we did was we pushed the idea that we'd work with the criminal authorities to put the people in jail. We also started an international program, which is important, the whole international area, and we should probably come back to that. And another thing we did was we really improved the infrastructure, the ability to get information about fraud. Bob Petoskey, my predecessor, had started some very good programs in terms of gathering information. We got a lot of money invested in that infrastructure, did surveys, national surveys of fraud and identity theft. And again, we built on the work of some very good people, and it's a very important and successful part of the FTC.
Great. So let's move on to national advertising. The FTC hasn't been terribly active recently in challenging national advertising campaigns, but I understand that's not always been the case. Is that right?
Yeah, the history of the FTC is interesting here. In the 1970s, the FTC overreached. It went after national advertising with too hard of an approach. The FTC law at the time was felt that instead of measuring consumer perception by a reasonableness test, they measured it by lowest common denominator. Mm-hmm. And the lowest common denominator prevented some useful information from going to consumers. They also had a very good program called advertising substantiation, which was started in the 70s. The idea there is that when an advertiser makes a specific factual claim, like, my car gets 20 miles to the gallon, that they're not making that up, that they have a reasonable basis for the claim. The problem is in the 70s, the FTC was requiring sort of proof beyond a reasonable doubt. And that was a standard that prohibited some very useful information for consumers. So when I got there in the 80s in the Bureau of Consumer Protection, we did a couple of things. We established protocols, which the Commission released publicly, for how to define deception, how to use substantiation. The deception was a reasonable man test, and we added a concept of materiality. It had to be important to consumers. Substantiation, what we said, was a flexible approach, which is, I think, how it started, and we got away from this idea of proof beyond a reasonable doubt. Another thing that we did in the 80s, and this was to propose a definition of unfairness. The Commission had actually attacked ads that weren't deceptive as, quote, unfair. And Congress codified the definition in 1994. So when I got back to the Commission in 2001, this approach that we developed in the 80s was well established, but a couple of other things had happened. The FTC had encouraged self-regulation, and the Counsel of Better Business Bureaus had set up a program in the 70s that by 2001 was really flourishing, and that was people could complain about if their competitors' ads they thought were unfair, they could complain. It's a simple, fast process, self-regulation. It works well with the FTC as a backstop if somebody doesn't follow the ads. And also under the Lanham Act, there were a lot of private actions. So the FTC's role is less important than it was. We still bring national advertising cases. For example, we challenged an ad. Kentucky Fried Chicken, believe it or not, had an advertisement where the wife plops down a bucket of fried chicken and says it's health food. Well, that was a little too much, and so we challenged that ad and got a tough order against it. So the FTC is there, but it's not. It doesn't have to do as much as it did. I'm a little worried now, however, that the current agency appears to be returning to this idea in the 70s of very tough substantiation standards. And the problem with that is that if you require proof beyond a reasonable doubt, consumers will be deprived of some information that is useful in health claims, for example.
So let's leave that for now and talk about another area that's been getting a great deal of coverage recently, consumer privacy. Now, this is an area that you didn't really have to deal with during your early stints at the Commission, but when you were chairman, it did command a great deal of your time and attention. I think it's fair to say that's not an overstatement. So can you tell us how that came to be?
Well, what happened is when I was going through the senatorial visits in early 2001, people were quite concerned about privacy. In Bob Petoskey's administration in the late 90s, they had put privacy on the map. But privacy was defined in a very odd way, I felt. It was defined as, do you support notice and choice legislation on the Internet? And when I heard that, I'm dating myself here, but I was reminded of the old Peggy Lee song from the late 60s, early 70s, Is That All There Is? I thought that was very strange that privacy would be so narrowly defined. So what we did, my Bureau Director Howard Beals and I, we met with dozens of industry groups, with privacy groups, with consumer groups, with members of Congress, and we moved away from the notice and choice approach. And the approach that we adopt instead was an approach that said, look, when consumers say they're concerned about privacy, for example, on the internet, what they're concerned about was the misuse of their information. Their credit card information would get stolen, for example. So we turned the privacy policy to focus on the consequences of misuse of information. And out of that came multiple very important initiatives. The most important and the most visible in my 15 minutes of fame in life was we created the National Do Not Call Registry, which was certainly one of the most popular programs in the history of the government. Very simple. All you have to do is register your name on the FTC's list. You can do it by internet. You can do it by phone. And most telemarketing calls cannot be made to you. Now, under the First Amendment, the politicians can still call you. So around election time, you get a lot of phone calls. But it was successful in cutting out about 80% of the phone calls. The other thing that we did, and this was a new program again, we focused on information security. We didn't try to impose security standards, but we said that when people make promises that they're going to keep your information secure, what that means is they're promising that they're going to use reasonable methods. And we brought several big cases, one against Microsoft, one against Eli Lilly. And again, that's been a very important and successful part of what the Commission's doing. I'm a little concerned, again, that at the moment that the Commission may be moving too far in that area, because they are talking about, I hope they don't do this, but they're talking about imposing some fairly rigorous rules in the privacy area instead of the flexible approach that we adopted and it's used in the last 10 years.
So I'd like to switch now to the competition mission of the Federal Trade Commission. And given the agency's release of the proposed revisions to the merger guidelines earlier this week, it would be fitting to begin with the merger arena. Can you share with us your view of the evolution of merger analysis over the last 3 decades?
That's a really interesting and important topic. In the mid-'70s, I actually sat on the merger screening committee, which I obviously did as bureau director in the '80s. And before the Hart-Scott-Rodino Act, people didn't have to notify pending mergers. So what happened is you would clip, in those days you didn't have the internet either, people would clip newspaper services. And when they found out about mergers, almost always consummated mergers, they would investigate them and go after them. But the problem with that was there was a famous article written by Ken Elzinga in the '70s called Pyrrhic Victories. He discovered that when you could only look at mergers after the fact, even when you got an order to break up the merger, they weren't often very successful. So the Hart-Scott-Rodino Act passed. And when I returned to the Bureau of Competition Issues in 1983, Hart-Scott was in its infancy, and there were the 1982 merger guidelines, which were still a very structural approach. What I mentioned in the introduction of big versus bad was still pretty applicable then. But what started to develop when I was there, and what's really taken hold in the '90s and now, is you need a story of what's wrong with the merger. You need more than numbers. Even if it's a 4-3 merger, you need to say why. Why is there a possibility of so-called unilateral effects or coordinated effects? That began in the '80s, but has really come to fruition. The other thing that started in the '80s was the focus on remedies. Again, what kind of remedies would you require to make sure that the relief worked? And subsequent chairmen have evolved the remedial approach, I think, largely successfully. Finally, in the '80s, one thing that we started was people who were failed to file or failed to follow the Hart-Scott-Rodino rules. We started bringing cases against them, and that's become a prominent area. So if you flash forward to 2001, when I returned, we did several things that I thought were important and set the stage for the recently proposed revision of the merger guidelines, which I think are appropriate. One thing that we did is that we released data about what the FTC had done in the '90s and in my tenure. We released statistics on the number of 4-3 mergers challenged and not challenged. We released statistics by industry. We released statistics on when was entry important, when were consumer complaints important. And we also started issuing detailed statements in individual cases, the Cruise mergers and others, for example. was an idea to increase transparency. And finally, we began what became, after I left, the merger commentary. All of that, I think, set the stage for what's happened now, which is proposed new guidelines which reflect reality, which is that the 1992 guidelines, which were the latest revision of the guidelines, were out of date in explaining what the agencies did. But I think the public transparency that we initiated was really instrumental and set the foundation for today's changes.
There were a couple of other initiatives in the merger arena that you launched when you were chairman. Could you talk a bit about the hospital merger retrospective and perhaps the consummated mergers that you reviewed?
Sure. What happened in the hospital area was when I arrived in 2001, the government had lost 7 straight hospital merger cases. Now, I'm perfectly willing to believe that the government makes mistakes, but 7 for 7 was just highly unlikely. So what we did was a retrospective of mergers, consummated mergers, to see just what the effects were, because we wanted to convince the world and the courts, if it turned out to be true, that some of these mergers that were allowed were actually bad for consumers. And indeed, we found that out, and we brought a case in Chicago involving a consummated merger, where we did a natural experiment, a study of what happened to the prices of the merged hospital against hospitals nearby, and the merged hospital had raised its prices. It was actually in a relatively geographically isolated part north of Chicago. The commission brought a case and eventually found against the merger. And that was part of a more general issue to focus on consummated mergers. And we brought other cases against consummated mergers. What had happened is the government, the Congress, had appropriately raised the threshold for filing mergers. It had been very small mergers were reported. It raised the threshold, but that meant that occasionally, probably rarely is a more appropriate word, there would be an anti-competitive small merger. So we found a few, and we challenged them. I think it was, again, another good initiative.
Thank you. So the Federal Trade Commission and the Antitrust Division both share responsibility for enforcing Section 7 of the Clayton Act. Despite the fact that the agencies are enforcing the same law, they face very different standards when they seek a preliminary injunction in federal court. Can you explain how this situation arose and what can be done to remedy it?
Well, this is a very recent and unfortunate development. Through most of the history of the FTC, although de jure the standards were different, de facto, they were quite similar. And indeed, in 1995, Bob Petoskey issued an important statement where Bob said, if we lose in federal court our preliminary injunction, we're highly unlikely to use our administrative process to continue to attack the merger. Now, justice doesn't have an administrative process, so he was trying to make the two more together. In the last few years, unfortunately, there is a clear difference between the two agencies. The FTC has succeeded in 2 respects of creating this difference. The first is when it seeks to get a preliminary injunction. A couple of recent decisions in the D.C. Circuit have essentially said the government can get the preliminary injunction even if there's a tie, even if the evidence is equally balanced. If that would happen with the Department of Justice, no injunction would issue. So you have the same statute enforced by 2 different agencies with 2 different sets of rules. And that's fundamentally unfair, because what that means is the 2 agencies have a clearance agreement. And they divide up, the Hart-Scott-Rodino Act actually says, in effect, only one agency can investigate a merger, so they divide them up. If you happen to be an FTC industry, then you're subject to stiffer rules than a DOJ industry, and that's just unfair. The other thing that they've done is they, in effect, have repealed the Petoskey policy. If they lose in federal court now, they have stated, although it's somewhat fuzzy, but they have certainly indicated a willingness to continue. And again, that's fundamentally unfair. And in recent testimony in Congress, I suggested that Congress follow the Antitrust Modernization Commission, which said we ought to make the 2, which came out a few years ago, and they said we ought to make the 2 agencies enforcing the same statute on fairness grounds, we ought to make them alike.
Thanks. So let's turn now to Sherman Act Section 1, enforcement. A review of your track record when you were Bureau Director and then when you were Chairman reveals that there are several common themes that you pursued during both of those tenures, and one of them was a heavy reliance on Part 3. So for the uninitiated, first, can you explain what Part 3 is, and then can you explain your reason for relying on it so heavily?
Sure. Unlike the Department of Justice, the FTC can bring cases administratively. The FTC, besides being an enforcement agency, is a judge. And the FTC brings these cases before an administrative law judge, and they're appealed to the commission. As a commissioner, as chairman, I actually wrote a couple of opinions. If you look since 1980, there have been two spikes in Part 3 cases, and one when I was Bureau Director and one when I was chairman. I believed in aggressively enforcing Section 1 of the Sherman Act. And I was blessed with something that my predecessor didn't have, which is I didn't have a merger wave to confront. And so we had more resources. We also got a budget increase. We had more resources. And one of the things that I've also done that's been important through the years is we looked at how to do the so-called rule of reason. Section 1, for a long time, you've had a rule of reason. And the courts had really divided the cases into two disparate boxes, the per se and rule of reason. Starting in 1979, the court backed away from that. The Supreme Court. And we tried to put some flesh on the bones. First thing we did was with the Department of Justice, we filed a brief in the NCAA case in the mid-'80s. And for reasons I've never completely understood, Justice let us write the brief. I mean, the Solicitor General and the Antitrust Division weren't all that enthusiastic about our approach, but they let us do it. And the approach led to what's became known now as a truncated or quick look rule of reason. The approach we adopted was actually formally put out by the Commission in a case called Massachusetts Board. When I returned to the Commission in 2001, we had a chance to revisit the Massachusetts Board issue. And an opinion in the Three Tenors case, which I wrote in 2003, and which was upheld in an opinion by a respected antitrust judge, Doug Ginsburg, in the D.C. Circuit. He blessed our approach. The Three Tenors approach is actually somewhat different than the Massachusetts Board approach, which I think some commentators have missed. I think since I helped author this, made a mistake in Massachusetts Board. We made it too easy to bring a case without applying a full-blown rule of reason. And I think Joel Klein made the same mistake when he did something called the quick look. Something called the stepwise approach. What we had said, if there's a basic restraint on competition, then you can avoid the full rule of reason, which requires defining markets and finding market power. The problem with that is, if you take mergers, for example, there's no more basic restraint on competition than a merger. I mean, it eliminates all the competition. But we know that mergers require what amounts to a full-blown rule of reason. So when we wrote the Three Tenors case under my name, what we said is you have to rely on economic learning and judicial experience before you go down this quick look road. We also said once you're in that quick look road, there are ways to get out of it. And I think that's an important part of it too. I'm worried again about what's happening at the Commission because I think they've issued a recent opinion and a recent amicus brief. They may be ignoring what we did in Three Tenors and going back to Massachusetts Board and making it too easy to go in this truncated approach where there are cases where they should be, really defining markets and looking at market power.
Another common theme that emerges if you look at both your Bureau Director tenure and your chairmanship is an attention to the professions. And I'm wondering, what prompted your focus in this area?
Well, a couple of things. When I first got to the FTC in the mid 70s, we were concerned about state law and private restraints on advertising. And many of those came from the professions. The professions really felt that advertising was unethical, especially our profession, lawyers. So we developed an approach following George Stigler, who won the Nobel Prize in the 80s, wrote a very famous article where he said that advertising, this seems common sense, economists can be slow to gather information. Economists really disliked advertising for a long time. But Stigler said, look, advertising is an immensely powerful tool for the elimination of ignorance. When you ban advertising, it turned out banning advertising raised prices. That's what the economic studies showed. One of the early papers that I published as an academic, and besides being in the government, I spent more time in my life being an academic, and I've written probably about 40, 50 papers involving FTC, antitrust, consumer protection issues. One of the earliest ones studied legal clinics, and we found that legal clinics on simple procedures, divorces, simple wills and all that, not only lowered price, they had equally or better quality. And the reason they could do that is they specialized. And what we did in the paper was, Fred McChesney and I, we did a study of the child support that was awarded in cases legal clinics did compared to traditional lawyers, and we found that when you control for all the variables using something called regression analysis, that the legal clinics actually did better, and they had a lot lower prices. And the reason is the advertising allowed them to get a big volume and to specialize, and when you specialize, you can often do things better. So we really focused on the professions. In all three of my tenures at the FTC, all four of my jobs, not only attacking advertising restraints, but we brought numerous cases against price fixing by doctors. We brought cases on other restraints of professional associations. I think that they should compete in the market just like everyone else.
Now, another common theme that emerges across your roles at the FTC is an intense focus on activities that violate Section 2 of the Sherman Act. Would you describe what you view as some of the most important initiatives that you launched in this area?
Sure. Section 1 of the Sherman Act, of course, deals with agreements, and Section 2 deals with single firm behavior. It's one area that's controversial. It turns out, ironically, that we brought more cases when I was chairman involving Section 2 on an annualized basis than anyone since the 70s. But they were a different kind of case. They focused on so-called cheap exclusion. And cheap exclusion means that, for the most part, you use the government to hurt your competitors. And it's cheap because, instead of spending a lot of money yourself, you get the government to do it. And there is protection under the law. The First Amendment allows you to petition the government. But if you use the government really for just an anti-competitive reason, then you don't get that First Amendment protection. And let me give you, a couple of examples. In the 80s, we sued U-Haul. U-Haul was a creditor of its only important competitor. And what U-Haul did was when that competitor went into bankruptcy, it acted in the bankruptcy like a competitor, not a creditor, drove the other creditors nuts because it was trying to delay the reorganization. So we sued them and got a successful result. When I was chairman in this century, we sued Unical. And what Unical had done, California has something called the California Air Resources Board, CARB. And CARB imposes, because of the pollution, tougher gasoline standards than in most states. So they were reformulating their gasoline. And Unical came forward and said, we have this non-proprietary process that will really be a great way to reduce pollution. So CARB adopted it. The Unical's competitors spent literally billions of dollars retooling their refineries. And then Unical stood up and said, we have a patent, pay up. Well, we said that's an antitrust violation. You lied to the government. That's misuse of the government. We sued them. I wrote an opinion about that case, and ultimately Unical settled, and it got billions of dollars back for consumers. A final result, Bristol Myers Squibb was the big drug company, was going to the patent office and saying one thing, and then it would go to the FDA and say the exact opposite. And it would say the one thing to the patent office to get a patent. It would say something different to the FDA because there's a arcane procedure there that allowed them to restrict generic competition. We said that's unfair. Unical settled. We worked with the states. Again, we got over time what it amounted to billions of dollars back for consumers. So those sorts of cases, fishing where the fish are in cheap exclusion was a great thing to do, I thought. The second thing we did, again, misusing the government, involved what's called the state action doctrine. If you go to your state legislature and get your state legislature to restrict competition, that can be protected, but you've got to dot your I's and cross your T's. What you have to do is you have to get the state government to clearly say they don't want competition, and then to supervise the lack of competition. So in the 80s, in one of several cases that we had that went to the Supreme Court, we had a professions case involving the Indiana Federation of Dentists. We sued trial lawyers in D.C. for price fixing. That went to the Supreme Court. And we sued the title insurance industry in many states for fixing prices, and that went to the Supreme Court. All three times the Supreme Court ruled in our favor. And what the title insurance case involved was the state gave the title insurance industry the authority to fix prices and didn't supervise them. And the Supreme Court said, you can't do that. Similarly, when I was chairman, we sued the South Carolina Dental Association, another example of a professional case. What they had done, and it was particularly egregious, South Carolina had a program under its laws where poor children could get treated by dental hygienists for simple things and get some preventative treatment. And the dentist passed a rule that said you had to have a dentist present. Well, that eliminated the program, and we said that's illegal under the antitrust laws. You don't have really state authority to do that. And again, we were successful in that case. Finally, in that area, we sued several state. In many states, you have intra-state. You can hire an intrastate company to move your goods. If it's interstate, it's regulated by the Department of Transportation. But if it's intrastate, it's regulated by the state. And in many states, the state said, you can fix prices and we're not going to supervise it. We sued a bunch of them, again, successfully.
So moving away from the enforcement missions of the FTC for a moment, the economists at the FTC frequently engage in self-deprecation. David Sheffman is just a great example of that. But I once saw Michael Salinger give a talk in which he described economics as the linchpin that holds together the missions of the FTC. Could you give us your opinion of the role of economics in the work of the agency?
Sure. I'm a product of the so-called law and economics movement. Law and economics is very important in influencing the law and in influencing antitrust. It's interesting. In the 70s, it was still up for grabs. Is antitrust about economics and nothing else? That, believe it or not, was contentious in the 1970s. There were people who thought antitrust should protect small businesses, for example. Well, that debate is really over. And the focus now, through many Supreme Court cases and many government pronouncements, is about economics. In consumer protection, it's still contentious in certain ways, but the reality is enforcing those simple rules that I mentioned, the rules against fraud, the rules against deception, et cetera, are really based on economic principles to help protect the consumers. And the idea that you need a federal agency because of the deficiencies of the private law process, again, that comes out of economic analysis. I think many consumer advocates miss the point of the benefits of markets. And again, the FTC is not the star player. The FTC tried to be the star player in the 70s. It failed, and it failed miserably, and it should be a referee. It's an important role, but the agency needs some humility.
Right. So you're talking about the importance of markets again, the gospel of competition. You've always been very enthusiastic about emphasizing the importance of competition advocacy. So when the International Competition Network was launched, when you were chair, you encouraged the organization to tackle competition advocacy as one of its first projects. Can you explain this emphasis on competition advocacy through the years?
That's another important area. Bob Potowski and I published in the Antitrust Law Journal in 2005 a conversation between the two of us, and it's subtitled more than an enforcement agency, because the FTC really has a very important role in what you can broadly call, in Bill Kovacic's phrase, competition research and development. The origins of the FTC are over 100 years old in something called the Bureau of Corporations, which when the FTC Act passed in 1914 was folded into the FTC. The Bureau of Corporations was not a law enforcement agency, it was a study group. And the FTC over the years has been responsible for dozens of reports that often led to legislation, they led to public action. That's one important function. Another important function, which began in many ways in 1974, is filing comments before other federal and state agencies on behalf of consumers recommending more competition. Lou Engman, who was chairman at the time, he decided he wanted to criticize the Interstate Commerce Commission and the Civil Aeronautics Board for being anti-consumer. He went out and gave a speech. It was front page news in the New York Times, a federal regulator criticizing other federal regulators. Now Justice Breyer was working for Senator Kennedy on the Senate Judiciary Antitrust Committee. He's a big proponent of law and economics, Justice Breyer. He got Senator Kennedy's ear. Senator Kennedy became a big proponent of transportation deregulation. It became bipartisan, and the FTC helped launch it, and I was proud of the minimal role that I had in that. In the 80s, we really expanded the advocacy program, and when I came back to the commission, we continued to do it across the board. Now, an adjunct to advocacy, and Bob Potofsky returned the agency to this function, going back to the Bureau of Corporations, is to write reports and to have hearings. Bob had a set of hearings in 1995 about international competition and consumer protection. One of the things that it led to was the FTC's focus on the internet, which has been a great focus in consumer protection. We held two sets of hearings when I was chairman. One was on the patent issues, and we discovered, as a lot of people think, that there are too many patents being issued, that it's a real problem in the world. There are people called patent trolls now who accumulate large numbers of patents, and they go out and try to hold people up for money. They don't produce goods; they just have they just have patents. That report, which came out in 2003, and another report which came out about the same time from the National Academy of Sciences, sparked a reform movement. There's legislation which has been introduced. Hearings have been held. We're in 2010 now. I think there's a good chance that legislation, which we helped start, will become law. We also held a set of hearings which unfortunately have not been as influential given what's happened in the country, but it was about health care, and we released a report in 2004 calling for more competition in health care. And unfortunately, with the passage of the recent legislation, I think the country is moving away from reliance on the market, and I think that's unfortunate.
So you've described the FTC as having a vast arsenal of tools at its disposal to enforce the antitrust laws. Can you give us an example of what you mean?
Well, I think a great example is the pharmaceutical industry. In the pharmaceutical industry, the FTC employed all of its tools. The FTC was asked by Congress to do a report on this arcane Hatch-Waxman Act. We did the report. It led to new regulation and new legislation. We filed amicus briefs on this NOR issue, this issue of petitioning the government. That was successful. We brought cases like the Bristol-Myers Squibb case that I mentioned. We held hearings dealing with pharmaceutical issues as part of the patent, as part of the patent report. When you think about it, it's like hitting for the cycle in baseball. Yes. We applied all those tools to what's a very important issue. The FTC has continued to do that, and I think it's perfectly appropriate.
It is quite an arsenal of tools that the agency has. Now let's go back to one of the things that you frequently said when you were chairman. You mentioned that you love being at the FTC because the issues are fascinating and the people are great. Can you explain for us whether you've seen a change in the people that are in the FTC community over the years?
It really has been fascinating. As the only person ever to head both bureaus, I'm frequently asked, which one did you like the best? And I have two sons, and I told them that's like choosing between my two sons. They're different, and I love them both. In the 70s, the FTC was full of young, inexperienced people, and there were a lot of policy entrepreneurs. They were really independent. They weren't supervised, and that's one of the reasons the FTC got into trouble. there were these literally dozens of independent entities. The FTC grew too fast, got too many people, got too much money. It's just hard. When you double in a few years, it's hard to supervise everybody. What happened when I came back in the 80s, a lot of those people had left. We encouraged them to leave. We imposed, the agency got smaller. We imposed more supervision. There was a core of people left who had learned the lessons of the 70s. We shifted the agency to this enforcement of basic common law rules. Some good things that had started in the 70s, like the professions, the focus on substantiation, properly done. We continued those. We developed those. We began the fraud program and some of the other things I started. And what's happened now is you have this great cadre of professionals at the FTC. They're very experienced. They're very good. My hat's off to them. They are great people. But something has happened now that is a little troubling. I gave John Leibowitz, current Chairman Leibowitz, had his first senior staff retreat in 2009, and he asked me to be the lead-off speaker. And one of the things that I noticed, I said, look, this is the first group where if you looked around the room, there's no one here in a key position who lived through the 70s at the FTC. And that's dangerous, because if you lived through the 70s, you saw the agency overreach. And what's happened is, in a lot of areas, the baby boom is retiring. There are still some people in mid-level positions at the FTC who remember this. But as the FTC goes forward, the collective memory that has helped the FTC become one of the worldwide's most venerable agencies, that collective memory and the humility that I think is so important, that's not there. And and given the mood in Washington with the election of the new president, I think there's an effort to push the FTC, just as there was in the 70s, into dangerous ground.
Another area in which the FTC has witnessed significant change in recent years concerns the globalization of both antitrust enforcement and consumer protection enforcement. So you launched notable initiatives when you were chairman in both of those areas. Would you describe them for us?
Sure, and that's another area, Christine, where life has really changed. In the 70s, and even in the 80s, it just wasn't that important. In the 80s, there were consultations. I went to Japan, had consultations, had consultations in Brussels with the Europeans. There's an OECD committee. It was at the periphery of what the FTC does. When I came back in 2001, it's now at the center of what the FTC does in both missions. Let me start with antitrust. We created the International Competition Network. It was launched in 2001 at Fordham. It had its first meeting in 2002 in Naples. And it's become an all antitrust, all the time organization with something like 100 agencies from around the world to try to work on educating people, on sharing ideas. And one of the most important things that it's done, we talked about advocacy before. A lot of these new agencies came out of non-market economies who are transitioning to the market. Again, the worldwide debate over the market, I think, has largely been successful, that the market is the best way to organize the economy. And we set up whole informational and instructional methods for these people in these agencies to know how we go about advocacy. You have sophisticated and long-standing agencies like in Brussels. You have a lot of agencies with the FTC model, the Canadians, most of the English-speaking agencies, countries have the FTC model. They have it in Britain, they have it in Australia, they have it in Canada, they have it in the US, where you combine the two missions. I think that's important and complementary. I think having competition gives consumer protection a market orientation, which it wouldn't have if it was alone. The consumer protection people, I think, focus rigorously on facts, and I think that helps. I mean, the two agencies are the two parts of the agencies are complements. They are different people. They used to even dress a lot differently. The BCP people were much more casual than I grew up in Southern California, so I was into the informality. Now they dress a little more alike. but they are different people with different focuses. And what the ICN allowed is really this focus on antitrust all the time. In the consumer protection area, it was behind the antitrust area in international cooperation. So at Fordham in the fall of 2002, I launched a 5-part consumer protection international initiative, and it was very successful. One of the places to start was to increase international cooperation in fraud cases. It turns out that because of the internet and the telephone, fraudsters have gone outside the United States. The FTC was successful in chasing a lot of fraudulent telemarketing out of the U.S. It went to Canada. Well, cooperation with Canadians, and I bless the Canadians for this because they had people set up not to defraud Canadians but to defraud Americans. They thought that was bad. We worked with the Mounties, the Royal Canadian Mounted Police. We worked with other Canadian enforcement agencies and have helped end a lot of that telemarketing. But a lot of the fraud is beyond Canada and beyond the U.S. It's over the internet. So one of the things we did was we got the OECD to focus on fraud, to get agencies around the world to cooperate attacking fraud. That was successful. You're never going to get rid of fraud, but the more people attacking it, the better. We proposed federal legislation to make it easier for the FTC to cooperate. That legislation moved significantly while I was chairman, and then after I left in the next Congress, it passed the so-called Safe Web Act. And again, the internationalization of consumer protection, just like antitrust, it's a fact of life. It's a prominent part of the job, and it increases and enhances the enforcement ability of both competition and consumer protection.
So throughout the interview, your comments have indicated you have a great deal of respect for the Federal Trade Commission, and I think your continuing role in connection with the agency through testimony and through speeches and through articles demonstrates you are concerned about the legacy of the institution. We have just a moment in closing, but if you could share with us words of wisdom that you might give to future heads of the agency, that would be great.
Well, I am concerned. Having lived through the 1970s and seen the agency overreach and seen the agency reach the pinnacle that it's reached now, the temptation is there. Debbie Majoris, who succeeded me as chairman, was asked this question publicly. You do not call yesterday. What are you going to do today? And she said, that's not the way to think about it. We do what's appropriate. We do when it's appropriate. And the idea that you're out to maximize headlines is dangerous. But with Congress now pushing the FTC to be more aggressive, I'm concerned. And I testified recently, a long set of testimony before the Senate Commerce Committee. There is legislation moving that would increase the FTC's power in 3 areas. The first is in rulemaking. Congress was concerned that the FTC, it's not a sector-specific regulator. The FTC is an expert on certain things, but it's not an expert across the board. So it said when the FTC wants to do rulemaking, it has to have tougher procedures. The most important of those procedures is the requirement that the FTC designate what's called material issues of disputed fact and allow cross-examination. The new legislation would get rid of that. I think that's important and helpful because, one, it forces the FTC to think through the rules before it announces them. And in the 70s, it didn't do that. I published an article in 1982 called Rules Without Reason, which was very disparaging, as were many other people, of the way the FTC went about rulemaking before it had these procedures. Second, we all know cross-examination is a great tool for illuminating issues. The second thing that this new legislation would do would allow the FTC to have civil penalties in all cases. I think that's a mistake. There's several reasons. In consumer protection cases, the FTC already can get civil penalties when in most of the time it needs them. It gets civil penalties for order violations. It gets civil penalties for rule violations. In fraud cases, civil penalties are irrelevant because I mentioned the FTC can tie up assets under 13B of the statute. What that means is the FTC gets all the money there is. It can go into court ex parte without the fraudsters knowing it, so the money can leave the country. It ties up that money. So civil penalties are irrelevant. If the FTC needs civil penalties in a specific area, like it says it needs them in information security cases, well, then it should ask Congress, and Congress can give it to them. In advertising, studies have shown that an FTC order without civil penalties punishes the company considerably because it hurts their stock price. When you're accused of being deceptive by the federal government and you're a legitimate company, that hurts you. In antitrust cases, the FTC, although the new statute would apply on its face only to consumer protection cases, the FTC has started to plead, like in the recent Intel case, which is an antitrust case, but it's also pled that it's a consumer protection violation. So that would allow the FTC to get automatic civil penalties. We don't need that, and it's just a distraction, and it's piling on. In antitrust cases, if there's a legitimate case there, you normally have follow-on private actions, and so the company has to pay lots of money. If there's a need for disgorgement, people have raised prices, and for some reason you can't have a private action. The FTC has a policy issued when I was chairman that under certain rare cases, it will get disgorgement, and indeed it's done that. But it doesn't need across-the-board civil penalties. The final issue is what the FTC calls pejoratively aiders and abettors, which is really liability on third parties. The statute would apply a uniform standard of what amounts to, if you knew or had reason to know that you were helping, a fraudster, you should be liable. Well, one, I think the FTC already has that authority, and it doesn't need it. But it has that authority on a case-by-case basis where it can develop different standards. Let's take fraud again. If you look at obviously false weight loss claims, well, the FTC has said for a long time, if you're an ad agency and you help someone prepare an obviously false ad, you're liable too because you should have known that. But the new law would say to the Washington Post or to a cable television station that it's liable as well. I think that violates the First Amendment, and I think if the FTC does go there, it should only go there with really tough standards, tougher than it applies to advertising agencies. So I'm concerned about all three of these areas. And the biggest problem is if it gets this new rulemaking authority, which would take away these special procedures, it's going to come with a congressional mandate which says you do the following 10 rules or 15 rules or whatever. When Congress reauthorized the Fair Credit Reporting Act, it told us to do 21 new rules. If the FTC is told to do a bunch of rules, it's going to transform the agency back into a legislature, and that's just not the role for the FTC.
Well, thank you for sharing your concerns about the legacy. And Tim, thank you very much for your time. We appreciate it.
Thank you. Nice to be here.